Under Canadian criminal law, there's many criminal offenses which are called dual procedure offenses. What that means is the Crown can elect summarily or they can elect by indictment. Let's take a sexual assault charge, for example. So let's say it's a simple, they're all serious, but a simple breast touching. The Crown would elect summarily in that case, and you would only have a right to be tried in the Ontario Court of Justice, which is the lower court. Let's consider a different sexual assault, which is, for example, a rape charge. The Crown's going to elect by indictment, which attracts much more serious penalties. Now, as the accused, that gives you much more rights to be tried. You can be tried in the Ontario Court of Justice, go directly to trial, or you can be tried by a judge and jury in the High Court, which is called the Superior Court of Justice, or by a judge alone in the Superior Court of Justice. Now, there's never a good thing about being, facing an indictable offense, but the one good thing is you have a right to what's called a preliminary hearing. You don't have that right on a summary conviction offense. Now, a preliminary hearing is something that happens well in advance of the trial, and it serves a screening function. Is to determine if there's enough evidence to proceed in your particular case. And it's a very low-level test. So we show up, the Crown calls the preliminary hearing, they call some of their evidence, and they call enough evidence to show that they have enough evidence to proceed to trial. The test is very low level. You rarely win. The defense rarely wins at preliminary hearing. And this is the test. You'll understand why. Is there some evidence upon which a judge or jury properly convicted? Some evidence. They could convict. Is there some evidence upon which a judge or jury properly instructed could convict? You rarely win. But the beauty of it is, as a defense counsel, you get a free crack at the Crown's witnesses. We get full discovery. We have a chance to create improbabilities and inconsistencies before the trial, pin down their story, and you're setting up strategically to win the trial. There's a real art form to it. You're not attacking the witness there. For example, let's say the witness on their original video statement said, well, he touched me on the left shoulder. And at the preliminary hearing, during cross-examination, you say right shoulder. Well, now is not the time to confront them that they had an inconsistency, because they'll explain it. Now is the time to say, you're certain, aren't you, that he touched you on the right shoulder? And they'll say, hopefully, yes. You have tied them down. Now you have a powerful inconsistency where you attack at the trial. So as a defense counsel, it's more softer cross-examination. It's full discovery. You're tying them down, creating those inconsistencies, lulling them into a false sense of security, not giving away your trial tactics. I see so many defense counsel make the mistake at a preliminary hearing of not proceeding that way and attacking the witness. Now the witness is ready for them at the trial. The only time you would ever attack a witness at a preliminary hearing is if you're almost convinced that you can win outright at that point and turn their story. And you have to explain this to clients. But it's a great right if you have charged with an indictable offense. It often serves the function of eventually winning your case just because you had that hearing. And the disadvantage, of course, with a minor offense is you don't get that right. You have to go right to trial in the Ontario Court of Justice. That's what a preliminary hearing, also called a preliminary inquiry, is all about.